Mr. Chair and honorable members of the committee, thank you for the opportunity to testify as part of a panel of witnesses in the study of Canada's sanctions regime. Tamil Rights Group is a not-for-profit human rights organization acting globally to support Eelam Tamils. We relentlessly pursue means to uphold human rights through global diplomacy, together with legal avenues under international law and human rights principles. In November 2021, TRG submitted a major communication under Article 15 of the Rome Statute to the International Criminal Court, requesting a preliminary examination into crimes against humanity committed against Eelam Tamils within territories of state parties to the ICC. Canada recently imposed sanctions related to Sri Lanka under the Special Economic Measures Act in, I quote, response to the gross and systematic violations of human rights occurring in the country. Sanctioned under CEMA were 4 Sri Lankan state officials who were responsible for gross human rights violations which occurred during 1983 to 2009 and afterwards. This was a great step in exposing the atrocity crimes, including genocide, that Tamils have been facing at least since 1948, and including the anti-Tamil pogrom of 1983, and most recently the 2009 Mullivaikal massacre. Numerous Tamils, including women, children, and surrendered unarmed militants were brutally murdered in the massacre, and death toll estimates range anywhere from 40,000 to 150,000. I am here today not only as a representative of Tamil Rights Group, but also a victim of the 1983 riots, which forced my family to migrate to Canada in 1985. Today, I would like to highlight TRG's view on Canada's sanctions regime and provide recommendations on how Canada can further strengthen the current regime. These recommendations are made in consultation with our legal advisors, David Mattis and Sarah Teach. Our first recommendation centers around greater transparency and more involvement from civil society and NGOs. We feel that there should be a clear and formalized pathway for NGOs to communicate requests to implement sanctions. NGOs can also access a wide variety of evidence that can help outline chain of command and identify perpetrators of gross human rights violations. Global Affairs should be working more closely with our group and others in the identification of evidence and perpetrators to be sanctioned. Second, more needs to be done to support justice efforts of Tamils, both in the form of additional sanctions and additional accountability efforts through various international justice mechanisms. This need is evident from realities on the ground. Sri Lankan officials continue to arbitrarily detain individuals under the Draconian Prevention of Terrorism Act. There is a continued military presence in the north and east of Sri Lanka, and individuals are prevented from participating in peaceful demonstration and acts of memorialization. Most recently, in the wake of alarming discoveries of multiple mass graves, the Sri Lankan government refuses to allow independent and international investigations and is willfully destroying evidence. These continued abuses highlight the need to expand the current sanctions. The vast majority of Sri Lankan officials with responsibility for gross human rights violations are still not held to account. Pervasive impunity encourages continued abuses. To combat this, sanctions must be extended to numerous additional personnel with responsibility for human rights violations, and any assets held by sanctioned individuals in Canada should be repurposed to compensate victims. Canada should also engage multilaterally to press for sanctions to be implemented in further jurisdictions. Canada should be investigating how it may be inadvertently undermining its own sanctions regime by still providing funds to the Sri Lankan military through agencies like the IMF and the World Bank. Further, targeted sanctions on their own are not enough. The utilization of the Magnitsky Act, or CEMA, is one tool among many that, when used in concert, may provide meaningful measures of justice and accountability. The utilization of international justice mechanisms is important. Sri Lanka and Canada are both state parties to numerous treaties, including the Genocide Convention and the Convention Against Torture, that enable the International Court of Justice to settle disputes. The International Criminal Court may open a preliminary examination into crimes against humanity committed against Tamils. on the territories of state parties. Canada should work to support these and other initiatives. We look forward to building on these engagements with this committee and would like to emphasize that the sanctions regime should be the first step in holding individuals accountable for gross violations. Canada needs to explore and implement additional measures, as this was also the recommendation of the United Nations High Commissioner's comprehensive report in 2022 that cited TRG's ICC submission. On behalf of Tamil Rights Group, thank you, and I look forward to your questions.